Document production in commercial arbitration. Don't go anywhere, because in 2 seconds you have the video that is going to teach you all about it. Hello everyone, my name is Maria Rubert, lawyer and arbitrator with a base in Dubai in the UAE for the past almost 15 years. I'm gonna try to teach you all about it, at least in a very practical way, to know what is document production in an arbitration, what do I need to know, how do I start. Yes, so document production. What is document production? Document production is a stage of the arbitration proceedings that where the parties can ask each other for documents. Documents that you believe that they do exist, that you do not have, and you believe that will be in your favor if the other party could submit them. Usually civil lawyers may be thinking, really they are gonna submit it? Common lawyers are certain that the documents that you request and your objections do not succeed will be submitted. Yes, this is one of the differences in between the common and the civil law systems, a mix of which is commercial arbitration. It's a mix of civil system and commercial system. Civil system, the written pleadings, of course, and the strength on the evidence, the fact that all the evidence must be included in your written submissions. And then we also have factors from the common law system, such as a witness statements. Of course, we also have this in the civil system, but it has greater strength in the common law culture. And then the document production stage is very common law based, let's say. Yes, so what are things we need to know? Usually there are timings in every arbitration. Usually no, there are timings in any arbitration. There is usually either the parties agree via terms of reference, or they do agree but terms of reference are not drawn, or sometimes they don't agree and there are procedural orders, such something that looks like this. I don't put it too close because I have some notes that don't mean anything, but I don't want to confuse you. Yes. So usually in the procedural order will say request for production of documents, and the party to do this is both parties. If you are a claimant or if you are a respondent, you are able to request for the documents. Then you will have the ability to object, yes, and then you will have the ability to reply usually, and then the tribunal will make a decision on the documents that must or not must be produced. Okay. So in order to talk about document production in commercial arbitration, it's very important that we talk about two things. Redfern schedule, I'm gonna be displaying it on the screen while we talk about it, and also the IBA rules on the taking of evidence in international arbitration. Version 2020 is the latest one. We are gonna be talking about document production, not changes, significant changes on this. Yes, we are mainly going to be talking about Article 3 and Article 9, and we're going to be going over that. Article 3 is very important when we prepare our request to produce, because it tells us what it needs to include. But first, let's jump into the Redfern schedule. The Redfern schedule is a tool. I call it an Excel. You can also have it in Word, however you want to have it. But it's the device that you see, the table that you see, that limits the information that you can request. Yes, you are seeing already the request number. Here I put 4 because it's an empty table. Really, you can have as many. You can have 1. You can have 10. Yes. Then you will need to include a brief description of the documents or categories of documents that you are requesting the other party to produce. Then the claim. Then next you will need to explain the explanation. I mean, this one has been prepared by us as counsel for a claimant party, yes, but it could be that we are respondents and then we just swap it. So the claimant's explanation, the explanation of the person requesting the document, of the party, requesting the document, explanation of the relevance and materiality to the issues in dispute. Very important. You cannot request just any document, yes? Well, you can, but it will be easily objected and easily dismissed, yes? Very good. In order to fill out these two columns, it's important that we go to Article 3.3 of the IBA Rules. I'm going to read it to you. It's very important. So, Article 3.3 says, a request to produce shall contain A, 1, a description of each requested document sufficient to identify it. Yes? 2, or a description in sufficient detail, including subject matter of a narrow and specific requested category of documents that are reasonably believed to exist. In the case of documents maintained in electronic form, the requesting party may, or the arbitral tribunal may order that it shall be required to identify specific files, search terms, individuals, or other means of searching for such documents in an efficient and economical manner. B, a statement as to how the documents requested are relevant to the case and material to its outcome. Yes, so it must be both relevant to the case and material to the outcome. Why do you think you have this? Who do you think is could get out of hand requesting documents? Common law lawyers or civil law lawyers? Yes, you're right. As this is a common law tool, in the common law tradition, this could get a little bit out of hand. So the reference schedule, together with, based on Article 3.3 of the IBA rules, helps limit the documents that you can request. Why? Because you could be walking into huge skeletons in the closet of documents, and this is time. Also, it could be a very good tactic to delay a proceeding. So this limits this possibility, and also costs. Yes, you go a bit crazy on the documents that you are requesting, and if you are not strong enough, and if you do not succeed, you could be forced to bear significant costs. So this is a way to limit, time and cost as well. Let's continue with Article 3.3. C, a statement that the documents requested are not in the possession, custody, or control of the requesting party, or a statement of the reasons why it would be unreasonably burdensome for the requesting party to produce such documents, and a statement of the reasons why the requesting party assumes the documents requested are in the possession, custody, or control of another party. So this is all information that you must take into account when filling column 1 and column 2. Yes. Then the counterparty, the party from which you are requesting these documents, has the opportunity to object. In considering these objections, guess what? We are going to rely a lot on Article 3.3. Why? Because you could say this is not relevant, or this is not material to the outcome of the case. Yes. Is not that the description is not sufficiently detailed, for example. And also you can go to Article 9 of the IBA rules. Article 9, admissibility and assessment of evidence. First thing we learn is that the arbitral tribunal shall determine the admissibility, relevance, materiality, and weight of the evidence. Number 2, there is a list of the reasons that the arbitral tribunal can use on its own motion or at request of a party. Let's think about the schedule, the reference schedule, and the objections. Yes. So it can exclude document production for any of the following reasons: lack of sufficient relevance to the case or materiality to the outcome, legal impediment or privilege under the legal or ethical rules, unreasonable burden to produce, that the documents have been lost or destroyed, and this has reasonable likelihood to have occurred, the destruction or the loss. There could be grounds of commercial or technical confidentiality. There could also be grounds of special political or institutional sensitivity. There could also be consideration of procedural economy, proportionality, fairness, or equality of the parties. So all these Article 3 and Article 9 of the IBA rules are very important when we prepare our objections. Yes, and usually the replies strengthen our position. Replies are always for the party requesting, yes? So the party requests, objects, and the party requesting replies, and then the tribunal decides. Those are the usual timings. What kind of things can we be requesting? Over the years, I'll give you a couple of examples. For example, in one case, one party was saying, oh, we have suffered a lot of damage. You have caused to another party, to a commercial party, a big damage to us. So you can request for the audit statements. Oh, yes. So, but this could be a bomb because you ask for it, you get it, and you see that they have suffered. So you have to be sure of what you are asking, because you could be getting a hot bomb, a hot pie in your hands, and it goes against you. Yes. What else can you be requesting? You can be requesting for emails or WhatsApps, because maybe you're representing a party that no longer has access to its phone number, to the WhatsApp, but you know that conversations took place from a given phone number and you don't have it anymore. Yeah. So these are things that you can be requesting. You can also be requesting documents that are critical, that the other party tells that they sent to you and they don't evidence that they sent to you. So produce it. If your case is based on this, okay, what is it? Right? These are examples. Okay. I hope that this information has been of help if you are a party trying to understand what your lawyer is telling you about document production. If you are a student or a junior lawyer just starting your career in arbitration, that this has been of initial and practical help. For any questions, I always welcome questions that are general, that can be of help to other people in your same situation. So please, happy to take a look to those general questions, and of course specific as part of my day-to-day. If you like the video, you have learned a little bit, please do like it, please subscribe to get to information as soon as it is out, and also you can follow me on other social media, as I also post other information not directly related to my YouTube channel. I can only thank you for your time and loyalty to my channel. I know it's many of you that have been with me for a few years now. So thank you very much.